Hi, my name is Laura Leonard, and I'm an associate in the Privacy and Cybersecurity team of Hunton and Kurth in Brussels. Today, I would like to give you a quick overview on the legal basis available to companies for data processing activities in the context of the COVID-19 pandemic. As you may know, organizations must ensure that one of the legal bases under Article 6 of the GDPR or one of the derogation under Article 9 of the GDPR where sensitive data is processed, such as health data, is satisfied when processing personal data in response to COVID-19. As the legal bases available for personal data processing and sensitive personal data processing differ, I will first go over those available to companies for processing activities that do not involve sensitive personal data. There are several legal bases available to companies that process personal data in the current context. These include, first of all, the necessity of the processing to comply with a legal obligation to which the employer is subject. So let's say, for example, ensuring health and safety at the workplace or obligation relating to the public interest, such as the control of diseases or other sanitary threats. Second, the necessity of the processing for their legitimate interest in ensuring business continuity and protecting individuals who enter or visit their premises. In this case, a balancing test should be conducted and documented. Thirdly, under certain circumstances, companies may be able to argue that the processing is necessary to protect the vital interests of the data subject. On top of these three legal bases, companies may also rely on additional legal bases available at member state level. Now turning to processing activities that involve sensitive personal data, such as health data. As mentioned in that case, one of the legal bases of Article 9 of the GDPR must be satisfied. In their COVID-19 related guidance, DPAs in the EU have indicated that companies may be able to rely on one of the following legal bases to legitimize the processing of sensitive personal data in the context of the current pandemic. First, the necessity of the processing to carry out obligation and exercise specific rights in the field of employment and social security and protection law, in particular to ensure health and safety in the workplace. Second, the necessity of the processing for preventive or occupational medicine. And finally, the necessity of the processing for reasons of public interest in the area of public health on the basis of union or member state law, which must provide for suitable safeguards for individuals, such as, for example, professional secrecy. With that, I would like to finish this short clip by reminding companies that collecting employees' consent to the processing of their personal data, or in the case of sensitive data, explicit consent, generally will not be considered valid in the employment context, given the relationship of subordination between the employer and employees, and hence the fact that consent would not be considered freely given. Thank you very much for listening.